Thank you everyone for logging in. This week we started the submission process, which had a few hiccups, as you might imagine. But overall, I thought it went pretty well. There are some issues with the questionnaire that we're going to be addressing with the trustee. I think all of us on the Trust Oversight Committee are going to get together, go over those issues, and then speak with the trustee. There, are some minor issues that I think would make things go a lot more smoothly. But overall, I thought the process went pretty well. The system didn't crash. There weren't any major problems. So I think we're on track, and I think we are definitely getting a lot closer to getting this thing done. So let me start by going over the questions that were submitted, and then we can open it up and take questions. Okay, first question. Having submitted our supporting documents, will we have the opportunity to see and discuss the claim being tendered to the PG&E mediator on our behalf prior to its offering? So that presents an issue. Now, the problem essentially is this. There is not a function through which we can print out the document and then give it to you prior to submitting it. So we can certainly share the supporting documents with you. If, for example, you would like to see what the tree report is, what the structure report, any of those types of documents, that's no problem. We can share the narrative with you. But by design, they wanted to limit people asking for specific amounts. And so they created this where they're not asking us to submit specific damage amounts. What they're asking us to do is to provide the information. So we would provide the narrative, we would provide all of the supporting documents that we've gathered, pictures, all those kinds of things, personal property lists, but not specific amounts. And so unfortunately, it's not like some of our prior cases where we have a demand that we create that has all the supporting documentation and then we give it to them. I don't think it'll be a huge issue in terms of the final outcome, but it does make it a little bit more difficult to go over things beforehand. So the way that we've been dealing with that is that if you would like to see all of your documents before they go in, then that's no problem at all. Just let us know and we'll make a notation in your file and make sure we do that. However, it's not a situation where we're able to give it to you the way we would in a standard mediation where we have a demand that we've prepared. We can submit that to you before we give it to the other side. So just something to keep in mind. Okay, next question. If we have any issues with PG&E claims, not just the dollar amount, do we deal with them directly or with or through the law firm? Yes, you do go through the law firm. If you want to speak to them, I don't know. We haven't had that request come up, so we can certainly ask. But I think typically, and I know that at this stage, what they want to do is have us submit everything, get the initial offers, then send them back. Once they do that, then we'll go over it with you. If there are issues, if you decide that you don't want to accept that and you want to go on to the next step, then there will be another process which will be a lot more involved. You'll get the opportunity to meet with the neutral, explain your story, explain why you think the amount that was offered before was deficient, and then we can do it much more in much more traditional fashion. So that's the answer to that. There's not a process for you to speak with them at this point, but if it does go to that second level, then you will be meeting with a neutral who'll be making a recommendation. Next question. I am 86 and my wife is 82. Will we get early consideration because of our age? So it's a little bit complicated. In Superior Court, there is something called a preference statute, and it's Code of Civil Procedure, Section 36A, which states that if you're 70 years of age or older and you have a significant health issue, then you're entitled to a preference in trial setting. What the trustee has agreed to do is to do essentially the same thing here. So we don't have to file a motion the way we would in Superior Court, but if we notify him that we have people over the age of 70 who have significant health issues, then he is willing to consider them at the beginning. So this, the person who asked this question, 86 and 82, likely would qualify. Now, I do have to qualify that somewhat by saying that the way the trustee has explained it to us is that they are going to process at least a couple thousand claims before they get the first offers out. And they're anticipating that's going to happen in November and December, and then they will have a large amount of offers, hopefully several thousand, that will go out, and then we'll be meeting and reviewing those with all of you. So that's what we think is going to happen. Now, obviously, not all cases are going to be settled then. It's going to take, I believe, at least 12 months to get this done. Right now, the trustee has set December 31st of this year as the final time to submit claims. I think that's going to be extended, but I don't know that it's going to be extended by a significant amount of time, probably 90 days, maybe 180. So that's just kind of something to keep in mind. Yes, if you're elderly and have health issues, please let us know. We'll put you at the front of the line, but it's still going to be, I think, November or December before the first checks are issued. Next question. In the event that a plaintiff decides not to rebuild, what effect will it be if the property is sold before the lawsuit is finalized? So that's a good question. Now, the way that it works is this, and we've talked about this before, but just to refresh everybody's memory on this, there are two different ways to determine what the measure of damages should be. One is the diminution in fair market value. So you take the value of the property before the fire, let's say it was worth $500,000, and then you take the value of the property the day after the fire. It's obviously going to be worth much less. With a complete home loss, it could be worth, 10% of what it was worth before, so $50,000. There are some rare circumstances where it can be worth zero. That is not usual. Typically, vacant lots will have some value, so we are not going to be able to claim zero, but there is going to be a significant discount, likely somewhere between 75 to 90%. So that's the first measure of damages. The second, though, is a little bit different, and it allows you to recover the cost to repair your property, even if that cost is more than the diminution in value, and even if it is more than the pre-fire value of the property itself. As long as it's reasonable, and thus far courts have upheld up to 167% of the pre-fire value of the property as reasonable, then you can recover it. So typically we're looking at 125%, 150%, something like that. So obviously if you take 75 to 90% on one hand and 125 to 150 on the other, it's going to be in your interest to try and get the cost to rebuild. Now the problem is the only way to get the cost of rebuild is to qualify for the personal reason exception. And that's set forth in the jury instruction, which is the court civil jury instruction called CASI 3903F. And what it says is the plaintiff has a personal reason for wanting to repair the property. Now that personal reason can be anything. It can be that you like the way the property looked before. It can even be that you intend to sell the property once you repair it, but it's in your financial interest to repair that property before you sell it for any number of reasons. Anything like that, any personal reason will qualify. But if you do not intend to make the repairs, and certainly selling your property would mean that you could not make the repairs, so you will absolutely be disqualified, then you are limited to the diminution in fair market value. So the short answer, that was the long answer, the short answer is that if you sell your property prior to the suit being finalized, you're limited to diminution in fair market value, and it will limit what you can recover. Okay, next question. We would like to know if there is a list to make sure we are ready for our claim to be submitted. So there really isn't a formal list. what we need from each individual plaintiff is if they lost personal property, their personal property list, because obviously we can't do that without you. You're the only one who knows what you lost. If you need help coming up with values, we can certainly do that. And then we're going to need to do a narrative in order to go through what your non-economic damages are. Other than that, we can get the rest of it. The only things other than that we may need, if you're a renter and you don't have a lease, for example, if you were either renting informally or if there was a lease but you weren't on it, that kind of thing, then we're going to need some proof that you lived at the property. So you can get that either through your driver's license, or if that doesn't work, you can get a declaration from the landlord. If you can't get that because the landlord didn't know you were living there, you were subletting or something, then you would have to get it from the individual who allowed you to sublet. So that can be a little bit tricky. If you have a situation like that, let us know. But other than that, we're able to obtain the majority of the documents, and those are the two main things we need from you: the personal property list and the narrative. Next, with being underinsured, I built our home. Will I be compensated for my labor through the lawsuit? So that's an interesting question. Basically, the way that it works is yes, but it's not like you submit a bill for your time. What you do is you say, okay, we had a specific home, let's say, 3-bedroom, 2-bathroom, 1,500 square foot, and we want to rebuild that home. So you're entitled to recover the fair market value of the cost to rebuild that home. Let's say it's $300 a square foot, and so you multiply that by 1,500 and you get $450,000. You would be entitled to the $450,000. If you were able to rebuild your home more cheaply because you either acted as the general or the owner builder or whatever the situation is, you still get that money. So that's the way that you get compensated for your labor, but you're not in a situation where you say, okay, my time's worth X, and you submit that. So those are the questions that I have that were sent in. Chewy, what other questions do we have?
A few emails.
Okay.
One of them is, I was sent a questionnaire. Is this just to let us know what will be asked from us?
Yes. The protocol and the questionnaire and a number of other documents were put out on the website. So we got that and we attached it to, I think it was either the last or the one before that, the letter that we sent out. But the whole idea was that we wanted to make sure that anybody who was interested in that had it. Now, you absolutely do not have to fill that out. If we need you to fill something out, we'll let you know. But we wanted to make sure that anybody who was interested in looking at that material in more depth had the opportunity to do so. If you would like to do that and you don't have either the link or the printed version, it is available on our website. You can just go to our website. We have a page specifically for PG&E. It's called PG&E Lawsuit, and we have all of the relevant documents, including those that are there. Or if it's easier for you, you can log on to the trustees website, and they're there as well. So whatever's easiest, just let us know. Go ahead, Chewy.
Okay. Do Butte fire victims need to expect to wait for all other fire victims' claims to be settled?
No. All of the fire victims have to be treated the same. So I think Butte is going to be toward the front of the line simply because the damages are all worked up, so they're all ready to submit except for certain rare cases. But unfortunately, the way the trustee is doing it, and this is a requirement of bankruptcy law, is no group within a class of creditors can be treated any differently than anyone else. So the trustee couldn't say, I'm going to pay Butte first because they've been waiting 5 years, whereas Camp's been waiting 1.5 years, for example. None of that is permissible. Everyone has to be treated the same. The only exception to that is the preference, and that's just based upon the fact that that's a limited number of folks who are elderly and in poor health.
Thank you, Jerry. Another question is a follow-up on what was What was the answer to taxation on claims?
It's still being worked on, and we've retained an attorney in San Francisco who is going to write an opinion for us. And this is something that I've done in conjunction with the other members of the TOC, the Trust Oversight Committee, to submit to the trustees saying that 1099s do not need to be issued in these cases. That's our main position. The fallback is going to be if they do want to issue a 1099, then they can issue it to the attorney because all of the money is coming to us and then we can deal with it. Technically, though, under tax law, because we're a corporation, Singleton Law Firm, and they're paying it to a corporation, they do not need to issue a 1099. I think that's the preferable, but the fallback is if you feel like you have to issue it to us, we'll deal with it, and that way there won't be anything for individual claimants to have to worry about.
Thank you. It says, when will campfire clients be called to tell our story?
That depends on where you are in the process. So the narrative is the last thing that we do, unless, for example, some people want to get it done, and so they'll call and we'll put them in touch with one of the people that does the narratives, and we can do that. But typically the way that we do it is we wait until everything's done. So if you lost, let's say you were a renter and you lost your home, we'd wait until we had your personal property list and all of the proof, whether it was a driver's license, a lease, whatever it is, to show that you lived there. Then the last thing we would do is get your narrative, and then you'd be ready to submit. So that's the way that we do it. Once we do the narrative, barring some unforeseen circumstance, your case is ready to submit. So if you haven't been called, that's why. Again, that said, though, if you do want to set it up, Serena at our Sacramento office, Serena Webster, and her email is just Serena, SERENA, at slffirm.com. She is the one that sets all of those. So you can call the Sacramento office, you can call the main office, and we'll connect you to her. You can email her, whatever the easiest for you is, and set it up if it's something that you want to get done now.
Okay, there's a few more emails coming through, Jerry.
Sure, go ahead.
So you said in previous Zoom meetings, the trustee got going in April. Why the delay with the questionnaire?
Yeah, well, I think the thing that you have to remember here, and I know that it's frustrating, is that nothing like this had ever been done before. So this process was being built from scratch. And it's also the largest settlement, to the best of my knowledge, in the history of mass tort bankruptcies. And I think it's one of the 3 largest settlements in the history of the United States. I think I know of one that's bigger, which was the Gulf oil spill. I believe it was 2010 or 2011 in the Gulf of Mexico. There was that huge oil spill by BP. I think that ended up paying out about $15 billion. But, and I think there's one other one, but I know it's top 3, and it's the largest in bankruptcy. And the problem is, again, nothing like this had ever been done. And so that's what's taking so long. It's not just a question of coming up with a questionnaire. It's a question of putting all the infrastructure in place to handle the claims of 77,000 individuals. And so that's why it took so long. And again, I know it's frustrating. Please understand, I mean, it's frustrating for us as well. I wish it were going more quickly. We are now to the point, though, that things are being submitted. So again, November, December is the date that the trustee gave us when we spoke last. Hopefully that sticks. But if we get any new information, we'll let everyone know.
Okay, says here, since there will be no demand for the damages, will there be a summary of the damages listed on the sheet, which will be submitted to the trustee?
Yeah, so yes and no. The way that it works is that the questionnaire is asking for information and not so much amounts. There's only a few areas where you can put in amounts. Typically what they say is they'll ask for all kinds of information about the case. We put that in. But for example, if you have tree losses, there's no place to put in what the damages specifically are. Instead, it says attach your proof. So we would attach a report. So there really isn't that summary. We keep one internally, but it's not something that's put into the questionnaire. And again, I think they did that by design because they wanted to avoid the temptation of people putting in very large numbers and then getting disappointed when they didn't see offers that were anything close to those.
Thank you, Jerry. And has a decision been made on how the attorney fees will be calculated by the trust?
No, that has not. We're probably not going to know until we get the first few offers, and then we'll be able to kind of reverse engineer how they're doing it. And just to follow up on that, the reason I say that is this. One of the things we've gone back and forth on with the trustee and the various bankruptcy and tax lawyers is they wanted to give us an itemized breakdown of the settlement. And the problem with doing that, and the reason why myself and every other member of the Trust Oversight Committee was opposed to it, is if that is done, then it casts in stone what you have to do in terms of taxes. And obviously, I know everyone is going to pay their taxes, wants to make sure that they do, but at the same time, you do want to have flexibility to apportion what percentage is going for example, real property losses versus what's going for something that you are going to have to pay taxes on: lost rents, lost income, certain types of non-economic damages. If, for example, you didn't have any type of physical damage, no smoke inhalation, no anything like that. And so one of the advantages of doing a very vanilla type of offer and having them just give us a lump sum is that because we're very aggressive with our experts and we have them come in with high numbers, typically you as the claimant are able to look at it and say, okay, and you do this obviously with your tax preparer, but you look at it and you say, okay, well, this is what the expert said my real property losses are, and this is what my personal property losses are. In other words, you look at taxes, or you look at areas that are not generally taxable, and then you say, well, if I look at what the expert said I lost in these categories, it's going to come out to a situation where the vast majority of the amount I recover goes to those categories, and there's only a very small amount that's left over that is taxable. And if we do it so that the trustee is very precise about what the specific amounts are, and even worse, if they were to issue a 1099 for amounts that they deem taxable, then you as the claimant would lose all of that flexibility. So, and this is particularly true in the event that we're not able to get 100 cents on the dollar. Obviously, everyone wants there to be 100 cents on the dollar, but one of the things we knew about being in a bankruptcy is we might get less than that. And if we only were to receive, let's say, 90 cents on the dollar, then we want all of that money to go to things that are not taxable. We don't want it apportioned 90% to non-taxable, 10% to taxable. So not only are you not getting 100 cents on the dollar, but you're having to pay taxes on a portion of it. And so those were some of the discussions that we had with the trustee. And so we're optimistic that when they issue the initial offers, they're not going to break them down, and that gives you and your tax professional the maximum amount of flexibility. So anyway, I know that's a long answer, but that's why we have specifically asked that at least in the initial offers, they don't break it down that way. Anyway, go ahead, Chewy. Sorry about that.
Not a problem. Someone said that we have to prove that we were home the night of the fire and that we had to run for our lives. What is the expectation to prove that?
Well, I think prove is probably too strong a word if you think of it in the sense of, do you have video or something like that? certainly you are going to have to state that. But if you do a declaration stating that you had to flee for the fire, then 9 times out of 10, that's going to be enough. For example, if you live in an area of, let's say Santa Rosa, where the Tubbs fire hit, you're not going to have any trouble convincing anyone that, you had to flee for your life. Same thing if you live in an area of Paradise, which unfortunately is the vast majority of it, that was destroyed by the fire. Unless you were someone who went to work very early, there's a good chance you were home or you were in that area. Now, the exception to that is, and there are absolutely people that fall into this category, but this is where you're going to have to do a little bit more. Let's say you were visiting someone, and we have people like this. I mean, we actually have people who had to flee for their lives who just gotten in to visit relatives the night before. I mean, they were asleep in a home in Santa Rosa, and they woke up with the house on fire and had to flee for their lives. Now, their driver's license is going to show that they live back east, and they don't live here. So they're going to have to explain, well, how is it that you came to be in this situation? Same thing if you were visiting someone in Paradise or any of those. But that's the thing. If you live in an area where it's expected that you would have to flee for the fire, you're not going to have to do anything else. If you have one of those very unusual stories where you were visiting from out of town, or for example, you were a delivery driver who just happened to be in Paradise the morning it happened, anything like that, then we're going to have to provide a little bit more proof, and we can talk about what that can be. It can be a declaration from the person you were staying with. If we need to, we can look at your phone and triangulate and go back and look at the data. All that stuff can be done. It's just a question of whether or not it's necessary, and if it is, we can talk more about it and figure out what to do in your situation.
Thank you, Jerry. If my insurance company has assisted in rebuilding, are they deducting that amount from our claims, or do we have to pay the insurance back?
In the vast majority of cases, you do not have to pay insurance back. The only exception to that is there are certain insurance companies that did not subrogate, and they're very small. They affect a handful of people. But for 99.9% of all the claimants, your insurance company subrogated, meaning that they filed their own suit against PG&E and they were paid. That was that big payment to the insurance companies that occurred and that a lot of people were upset about. Again, we talked about that. The reason for it is they took the big discount, et cetera. But the insurance companies have been paid. So the way that it's going to work is that we will submit your damages, and then they look at the insurance information, deduct what the amount is, and then the net is what you get.
Thank you. What was said on Tuesday's call about the questionnaire?
Well, we talked about the problems that we've come up with in terms of dealing with it. And these don't really affect the claimant so much. It's more processing. One of the issues we had is that, just to use an example, erosion damages are not in a logical place. Because of that, it's going to be more difficult and more time consuming for the people at Brown Greer to calculate those damages. And obviously we want to make it as easy as possible for them to calculate the damages so they can process more claims and get them done more quickly. So that was one example of what we talked about. There are a number of other issues that, again, they relate specifically to how the questionnaire is structured and how it can be improved to make it more efficient. But that's the main focus. And again, that's something that we're working on with everybody involved.
Okay, I have an email that just came in. It says, we've been issued new identification cards, driver licenses since the fire. Mm-hmm. Can we use our FEMA paperwork for proof of residency at the time of the fire?
Yeah, you can use anything you have. If you have FEMA paperwork, you can use that. If you have a utility bill, cell phone, whatever it is, We just need to be able to prove. And also, you can go back and get copies of prior driver's licenses. That's not a problem, and we can do that. So short answer is you can use anything that would prove you live there. The best is a driver's license. Next best would be a lease. And then after that, it would be utilities.
Okay, I'm going to keep on scrolling through, but we can open it up, Jer.
Okay, great. Yes, Mr. Olson.
Can you hear me? Can you hear me okay? Okay.
I can, yeah.
Now, in my case, we rebuilt the house and have completed that with the exception of some of the landscaping in the back. So I have been uploading all my invoices, detailing all the costs that I know that are, so it's my cost of rebuilding is well established now. And there's a very significant difference between that and what I was insured for. So when you say that there are no specific amounts that are being submitted, this is of some concern to me because I have those amounts that I've been planning to submit.
Sure. That's an interesting point that you bring up, and that when I said that no specific amounts are being submitted, I should have clarified and given you a little bit more detail. Here's the way that it typically works. If you are relying for proof of the cost of cure on an expert report, then you do not put that amount in. However, if in those rare instances, and it sounds like you're one of them, you've actually spent the money, then there is a section to say, give us every penny that you've spent out of pocket. And so we do include that along with any supporting documentation.
Okay, well, that's something reassuring. That's good.
Yeah. All right. Other questions? Yes, Neelam.
No, there's a.
All right, we'll come back to Neelam. Who would like to go in the interim?
Question about initial estimates that were done by Nautilus.
Yes.
Are you using those as damage amounts, or if the house has not been built?
Yes, it depends on the particular client. We've had a couple of people who have, and whether it's Nautilus or somebody else, who have elected not to use that and have decided to go with something else, which is fine. I mean, for example, they had their own builder and it turned out that was more and they wanted to use that, and that's fine. Typically, we're using either Nautilus or Larry Turner or whoever our expert is that did the report, provided that the client is in agreement with it.
Well, along that same line, I read the other day where building costs in the past year have gone up $100 a square foot. That's just last year, okay?
Yeah.
So if you're looking at Nautilus, you're talking 3 years ago, right? So is that accounted for, or is that?
Yeah, I mean, for each one, we can certainly take a look and make sure that it's still accurate. I think that building costs definitely have gone up, but for the most part, that was something that was anticipated into our expert report, which is why they're so high, frankly, is that they look at it and they say, okay, we know they're not going to be able to build right now. Here's what we anticipate it's going to be, and they factor in all of these increases. So we can certainly take a look at your case or at anybody other specific case, but my guess is that we're going to find that it has been accounted for.
Thank you.
I have a quick question.
Sure.
On the 41-page personal loss inventory forms that are brutal, can I mean, I'm through page 23. Under holiday decorations, as like, how many plates do I have? 7, 9? I don't know. Can I just estimate and give a total for that in women's clothing?
Yeah.
Like, how many of this did you have? It's like, I don't know, a
Yeah.
lot.
No, absolutely. And that's, no,
Okay.
understood.
Okay,
And-
okay. I just wanted to make sure that was okay to just say total is about.
Yeah, no, and again, for anything like that, and this goes to everybody, you know, you can only do the best you can. And there is going to be probably a number of things where you're going to have to estimate what it is that you lost. And that's completely understandable. So just do the best you can. And that's all anybody can ask of you.
Okay, I also had on that same topic, I had a lot of antiques for my grandparents, my parents, and my deceased sister. A lot of them were in storage in the front bedroom. It was like a mini storage.
Okay.
I have been trying online to find, you know, if it was Duncan 5, okay, can I find something similar? Is that how you do it? I mean, I don't know how you price them on things that you just, you know, it's shocking how much they were worth if this is the accurate way to do it.
Well,
I'm like, why didn't I have more insurance? I had no idea.
Right. Yeah, that's one way to do it, and that's certainly acceptable. You know,
Okay.
fair market value can be determined, and often is determined just by going online and seeing what you can buy a similar item for. So that's one way to do it. However, I know there's a lot of legwork involved there. So if you're not able to get prices for everything, please just give us, you know, your best description, and then we can find an appropriate amount by either looking online or going with an expert.
Okay, thank you.
Sure. Chewy, do we have any other questions?
Yes, there's a question here that says, I recently read that Sonoma County received over $400 million from our bankruptcy lawsuit.
Mm-hmm.
Why is it that they get cash withdrawal from the money? Also, is it coming from the 13.5 billion?
Yeah. Okay. So a couple of things there. I think they actually got less than that. They got quite a bit. I don't think it was 400 million. I don't know off the top of my head, but I do think it was significantly less than that, but it was a lot of money. Remember, there were three components, and let me just say, it is absolutely not coming from the same trust that the fire victims, the 13.5. There were three separate components of the settlement. There was the fire victims trust for the individuals, which is the cash and stock that has the estimated value of 13.5. Then there's the subrogation, which is 11. And then there's the public entities, which is 1 billion. And that's the County of Sonoma, County of Napa, County of Mendocino, County of Butte, City of Paradise, City of Santa Rosa, Lake County, Clear Lake, all of those places, everybody is getting paid out of that 1 billion. The reason they got cash as opposed to a mix of cash and stock is that they accepted a discount. It's hard to calculate exactly. I know the initial demand was well over 3 billion. There's obviously, you know, they're not going to settle for 3 billion, but you know, I think a reasonable settlement outside of bankruptcy probably would have been closer to 2. So they accepted a discount of, and Chewy here has indicated, Sonoma got 184 million, the county. But again, if you look at the overall amount, they accepted a discount of close to 50%, and that's why they received cash.
Okay, I have a few here in the chat. You mentioned the cost of cure is up to 167% of pre-fire value.
Mm-hmm.
Does that include the landscaping and loss of trees, or is the loss of trees in addition to the 167%?
No, the 167% was for all real property damages. So you're looking at cost to rebuild the home, any other structures, trees, landscaping, hardscape, you name it, it's the whole 9 yards. Mr. Olson had a question. Go ahead.
Yeah, if you don't mind me asking a second question.
Sure, please.
Let's assume for the moment that the trust is a value of 13.5 billion and it's not diminished by a stock valuation or whatever. Would you say that the legitimate claims would total like $9 billion. And from that, you would take half of that, which would be 4.5 that would go to the attorneys. So that in that case, everyone would be compensated 100 cents to the dollar. And then you would get the, a third of the total 13.5 on top of that. Or would the legitimate claimants total $13.5 billion, from which a third would go to the fire lawyers?
Yeah.
And we would get, the claimants would get 66% on the dollar.
I think it's a lot closer. The bottom line is nobody knows, and we won't know until all the claims are done. I think it's a lot closer to the first one, where we're talking about the actual amount of the losses being closer to 9 billion. A lot of models have it less than that. A lot of them have between 7 and 8. On the other hand, there are some that have it over 10. We just aren't going to know, and the reason for that is that we don't know really anything about a significant number of the claims.
Sure.
So if we assume that those claims are similar to all the ones that we do know about, then we think that the 13.5, and again, the stock has to go up to get there, but assuming that it does, we think that the 13.5 is going to be enough to pay everyone either 100 cents on the dollar or close to it. The problem is, if it turns out that those unknown claims are larger on average than what we've projected for, then there is going to be a shortfall. And that's just something we will not know until all of the claims are submitted.
Okay, very good.
Yeah.
Thank you.
Sure.
I think we had a question from Mr. Likas.
Sure, go ahead.
Yeah, can you hear me?
Yes, I can.
Oh, okay. We're sitting on sort of an unusual situation because my insurance covered just about everything except our personal situation. I'm the 86 and the 82 situation,
Okay.
and 56 years of marriage, and it's all gone.
Yeah.
Everything. The house is total ashes. We are going to rebuild, but it's probably going to be about a year. Now, I got an estimate from a contractor as to the rebuild, and it's higher than what the insurance paid us. Are they going to really consider all this stuff? I do have some medical issues.
Yeah.
And I just like to know, financially, we're pretty good right now, but I was just wondering if the lawyers could say something to PG&E, or do they have to go through the trust?
Yeah, it's got, well, and first of all, let me say, and I know a lot of people in this situation, but obviously the older you are and the more that you have, the harder it is. So 56 years of marriage, that's a lot of memories to lose. And I'm very sorry that you and your wife had to go through that. In terms of the expediting the process, what we're going to do and what Chewy's going to do is just make a note of this so that we can make sure that we put you in that preference category. But what we do is we talk with the trustee, and they're the ones that the trustee is the one that has to do it because PG&E is completely out of it. And we ask that yourself and any other preference cases get essentially put to the front of the line. And again, this is a very small number of cases. It's typically well under 1%, but 86 years old, obviously that's a different situation than somebody who's in their 30s. So I think that should be something that we're able to do, and hopefully we can get you compensated sooner rather than later.
It's just a time matter with us, because.
Yeah. Understood.
All right.
And we want to, we want to get it done.
Hey, thank you, and I am really appreciative of your law firm. They seem to know what they're doing. Thank you.
I hope so. Thank you. All right. What other questions do we have?
I do have a comment here. It says, we did not deal with FEMA except for lot hazard removal. We were told they were going to bill us the amount for the amount insurance policy covered, but they have yet to bill us. If and when they do this, is that something we should include in the costs?
No. What's going to happen there, and this does get complicated, so I'm glad you asked that question, but there's a couple of different ways that this can happen. Number one, a lot of times FEMA will just bill the insurance company directly. And when we say FEMA, it's really a group, typically the city or county, whether you live within an incorporated city or whether you live in just the county. The city or county, the state, and FEMA are all involved in that debris removal. Now, FEMA pays the most, so it's typically referred to as the FEMA program. But the reason that it's different everywhere is that there are different people who are administering it. Sometimes it's administered directly by the feds, sometimes it's administered by the city or the county, and everyone, unfortunately, has a different way of doing it. So what ends up happening is that they have you sign that right of access in which you say that you will agree to pay whatever your debris removal coverage is. And then they can bill the insurance company or they can bill you. And typically what they do is bill the insurance company, but sometimes what will happen is your insurance company will pay you and then FEMA will bill you. So what I always really stress with clients who ask about this is that if you've been paid debris removal, it's a really good idea to keep that in a separate account, because at some point FEMA is going to send you a bill. And then you can say, okay, here's what I received, here you go, and that squares you. There are times when, like any other organization, and thankfully this doesn't happen a lot, that the FEMA program overbills or, they bill twice, that kind of thing. If that happens, let us know. Typically we can make a call and get it squared away. But again, fortunately, that is something that does not happen with a lot of regularity.
I have a question along the FEMA lot cleanup.
Sure.
My insurance was really super. After the fire, the first thing I did was I took down trees and I called my agent. I said, is that covered? And he said, yes, that's under lot cleanup. So I took down 23 trees just in the back and he paid, I gave my estimate, he paid the tree people. Then I had to pay to have the broke down chain link fence that FEMA did not take because it wasn't in the burn scar. It was farther down, or in the footprint, it was farther down. And so he took money out of that account for lot cleanup. And when the weeds got like 4 feet tall, I had to pay someone to go in and clean that up. And he took it out of there. It turns out now that my lot, hopefully I'll be building at some point, but I have taken almost all of that money out for the FEMA lot cleanup. So insurance told me they can only bill me for what I have in that account. Does that sound right to you? Are they going to come after me for that?
Yeah, I've seen it both ways. Typically, if you've actually spent the money on lot cleanup, as you have, and they haven't billed you yet, then that's exactly what they'll do. There's an argument under the way the contract is written that they could try and bill you. But the thing is, that's such a bad look for the federal government to be going after an individual fire victim that, typically it does not happen. So I can't say for certain that you won't get billed for the full amount, but my guess is what'll happen is they'll just ask for the amount left in the account.
Okay, because my account or my claim is still open until they bill them.
Yeah.
And I think there's like $10 left. And I said, oh my gosh, what's going to happen?
Yeah. And again, I think because you've actually spent it on lot cleanup, you're going to be okay. But unfortunately, again, the way the contract is written, there is some gray area. So we'll have to wait and see.
Thank you.
Sure. All right. Who else has a question?
I have a quick question.
Sure.
Jerry Hamango here.
Yes.
My wife died as a result of this fire. PTSD. Nobody could hit for sure.
Yeah.
But of the paperwork that your people sent me, they're requesting a copy of my trust, and that is quite a lot of paperwork to send in. Could you give me a better idea exactly what is required that you would need? I know the power of attorney you want, and I guess you just want something showing that it was trusted to me from the wife, and the basics of the trust itself.
Yeah, well, anytime you have real property damage, if your property's in a trust, then the trust has to be a plaintiff. So we would need certain documents from the trust in order to be able to fill in all of the information that the Fire Victims Trust is going to be asking for. So that's why they're asking for that. If there's any kind of a power of attorney, then we would obviously need that. But that's probably the kind of question, because it's unique to you, that you want to ask individually. So we can, we can talk more offline and answer the question. Go ahead. I'm sorry.
Oh, yeah, I got you on that. So I understand better off to talk to you about it and have the trust right in front of me then.
Yeah.
And the second question I have was, I got a good settlement, what I thought was a good settlement from my insurance company for personal property to the tune of $95,000. And I'm just wondering if I still have to fill out that all that personal property stuff. I know they said I didn't have to originally.
Right.
So that's quite a lot to remember. I tried it a couple of times, and we get about 2 or 3 rooms, and suddenly I'm going back, and there's more keep popping up as the time goes on. So
sure. The answer to that is it's completely up to you. Most of my clients are underinsured in terms of their personal property. So it may well be that if you go through everything that you lost and you're able to complete it, you're going to find things that are above that $95,000 that you received. However, it's 100% up to you. It may be that you feel like, look, I think $95,000 is fair. I don't want to do this. That's completely reasonable, and you don't have to. We just want to make sure that you don't leave anything on the table so that we give you that opportunity. But if you decide it's not for you, that's fine.
Okay, that's so as far as determining the value of items, and of course you realize that in the fire, all the receipts that we had on anything, totally in ashes now, and washed down the river to who knows where. So, so it probably just estimate what the values would be on it.
Yeah, you can estimate it if you have a basis for doing it. And certainly, if you can remember what you paid, or what something like that costs, or, you can always go online. Another thing that we really recommend people do is, if you shop at a particular store, whether it's Target or Walmart or wherever, you can go in and register. You can do a gift registry. Then you can take the gun they have and go around and tap every item. And then it'll give you a printout of what it costs. So there's tons of different ways to do it. But if you want to talk to somebody from the team about better ways to do it, that's no problem at all.
Okay. Yeah, that's about all I have for now. Thank you, Gary.
Okay.
Appreciate what you people are doing for us.
My pleasure. All right. What other questions do we have?
Jerry, I have a question.
Sure.
And so my insurance company paid 75% of my personal property.
Uh-huh.
And so now I got a letter from them saying that it's been over 2 years and I cannot go back and get the next 25%. So with that letter, is that sufficient for them, for the trustees to consider paying out that 25%?
Yeah, it should be. The trustee can always say, well, I want you to submit this first, kind of thing. But that letter should certainly be enough to do it.
Okay, great. Okay.
Yeah.
Thank you.
Sure. All right, what other questions do we have?
I do have a question.
Yes, go ahead.
What tax liability do we have? And I
Right.
understand it may depend upon what you're being reimbursed for.
Yeah. You know, the problem is, I'm not a tax lawyer, I'm not an expert, so I have to preface it with that. I can give you the general rules, but I can't give you specific advice. We certainly can refer you to CPA, tax attorney, anybody you want. The general rule is that if you are compensated for loss to real or personal property and you replace it, then there's no tax liability because you haven't received any gain. You've lost something and then you've been paid for it. And so it's a neutral event. It gets very tricky when people do things like take a capital loss. That obviously means that anything you get for that's going to be a capital gain. Or if you have rental income, if you have lost wages, or if you have non-economic damages and zero physical injuries. So if you don't have any type of smoke inhalation, upset stomach from stress, burning in your eyes, if there's nothing like that, then there's a strong argument that non-economic damages are taxable. So that's why it's very important to look at the specific case, get with a professional, and then allocate it accordingly.
Okay, thanks.
Sure.
Gary, I do have a couple of emails.
Yeah, go ahead.
One is, I would like to know the exact number of PG&E shares that are in the trust.
I believe it's 485 million, but that's one of those things that if you email me, I can get it for you. It was 479 million, and then a certain amount were added 2 weeks ago. It was about 6 million shares. So I don't know the exact amount, but it's roughly 485 million.
Thank you. One more here. Do the people who received FEMA money have to return it?
No, you don't have to return it. And when you say FEMA money, it's going to depend on what type. If you just had the cleanup, then you're going to have nothing to worry about. If you received grants from FEMA, then it's going to depend on a number of factors. And so if the trust is cognizant of it and FEMA has made a claim for it, then they will deduct that amount from your overall settlement, but it just depends. I don't think we're going to have a really good idea until we see some of the initial settlements.
I don't have any more submissions here, Jerry. I'll keep on looking through the emails.
Okay. Any questions?
Yeah, I had a quick question.
Sure, go ahead.
Yeah, so I'm the general manager up here in Best Western Paradise, California, and I actually live on the property. I have a manager suite. How would I prove my residence?
That shouldn't be a problem. I think there certainly is going to be something that you have, whether it's, is your cell phone paid or do you have to get a bill for that?
No, I get a bill. I have a secondary house. I have my main house in Sacramento. I lived up here.
Got it.
My wife would come back and forth.
Okay. Well, you should be able to explain that. That shouldn't be a problem. And then if they want any more evidence, we can just provide them with a declaration from someone who is an executive at your company. So that shouldn't be a problem.
Okay. All right. Thank you.
Yeah.
Jerry, there's a comment here that says, is that the same for all assistance received, not just FEMA, as far as repayment?
It depends. If it's from a private organization, then there's no argument that you're going to have to repay it. If it's from a governmental entity, that has made a claim against PG&E, for example, the state of California or the federal government, then we're going to have to wait and see. But, you know, if you got something from the Red Cross, or I know Catholic Charities was operating in some place, the Methodist Charities were operating in some. I mean, there were a ton of charitable organizations involved. That is not something you're going to have to repay. It's really the state and the federal government.
I got a question.
Sure, go ahead.
First of all, thank you. And I was just thinking about the insurance companies getting all their money first. And I know that's rubs you the wrong way. It rubs me the wrong way also.
Yeah.
Now, did they get 100 cents on the dollar? I mean, like, let's say,
They got about 58. So their total losses were about 19.6 billion, and they got 11. And there are two reasons why they got cash and they got paid first. One is that they were willing to take such a big discount. But number two is that with insurance companies, it's very easy to determine exactly what their loss is. I mean, this is what they paid, so that's what their loss is. For individuals, homeowners, renters, property owners, it's much more difficult because we don't have those liquidated damages like we do for insurance companies. And that's why it's so much easier. And that's why in these cases, typically the insurance companies get paid first because number one, they're generally willing to accept a big discount. And number two, because their damages are liquidated, there's really no dispute over what those damages are.
Okay, thank you.
Sure. All right, who's next?
There is a question there about settlement payments. Will those only be sent out via by check, or is there a direct deposit option?
Typically it's by check because, and what will happen is the trust sends a check to us. We take out the attorney fees and costs. Then we do a breakdown for you that says, okay, here's what the costs are. Here's what the fees are. Here's what the amount was. Here's the net to you. You have a chance to look at that. If you dispute any of it, if you think any of it's wrong, by all means, let us know, and we'll figure that out. Once you are in agreement with the numbers, then you tell us how you want to receive it. Typically, we like to do it via check, simply because then there's a record and it's very easy. But you know, if there's some kind of a circumstance where it's difficult for someone to get a check or it's some extenuating circumstance, then we can arrange to wire it or something similar to that.
Thanks, Jerry. There is another email just submitted. It says, I had a lot of vintage music equipment gathered over a period of years.
Yeah.
There's really no proof of other than gathering witnesses to support that I own them. What proof would be sufficient to support a claim?
Well, certainly that. I mean, you know, typically if you're somebody who is getting vintage musical equipment, then you're either a musician or you're, you know, someone who loves music. And so you're going to be able to, you're going to have friends that have the same interests, and they're going to be able to say, yes, I was at his or her home and this is what I saw, that kind of thing. So I think you definitely want to get statements from people, but the best way to do it for something like that is to get one or two people who can really set forth what you had, talk with the person at the firm who's handling the case. We can prepare a declaration for them to sign, get that signed, and then submit it. And that, together with your statement, should be enough to do it.
Thanks, Jerry. Another question here is, what is the soonest settlement checks will be going out?
The soonest it looks like is November. You know, again, it might be a little earlier, it might be a little later, but if I had to bet, I would say it's looking like November right now.
Thanks, Chair. I don't have any more questions submitted.
All right, questions on the big board? Yes, Mr. Olson, go ahead.
Well, 3 questions may be beyond the legal limit. Let me know.
Well, that's fine.
So I understand from based on your previous comments that there are some issues, some questions with the trustee about the questionnaire. So my question is, when do you think those issues will be resolved, and when will you be submitting your first claims, or have you already submitted some claims?
Oh yeah, no, we've been submitting claims all week. It's just that what we found as we've submitted them is that we have perceived problems in the questionnaire, and we think if the trustee and the claims administrators make these changes, it'll make it go quickly. So what we're doing is we're speaking with the people at Brown Greer who are responsible for this, because remember, they're the entity that collates all this data. We're talking with the other members of the TOC, and we're trying to convince them to make these changes. So it's an ongoing process. It's been going on since Tuesday, and we'll see what happens. All right, other questions?
Okay, I have one.
Sure,
Of
go
the 77,000 claims, once they look through them and determine if they are legitimate, does that mean there may be duplicates and that is where they're going to weed them out? Or what determines what does that mean, legitimate, I guess? Or a
Well, the
valid
duplicates,
claim?
I'm sorry, go ahead.
Or just the valid claim? What is that? What do they do there?
Yeah, the duplicates have largely been identified because there were another 10,000 claims that were submitted, but a lot of those were duplicate. And so the 77,000 is our best estimate at the non-duplicative claims. So that's there. The legitimate claims, anytime you do something like this, there's always going to be some percentage that are not legitimate. And it could be that they are claiming to have owned a home when they didn't. They're claiming to have evacuated when they didn't. And so that's what they're doing when they're looking at them. And there really is no way to evaluate them other than to have them submit the documentation, then look at that. And if it checks out, then the trustee will pay it. If it doesn't, then they'll ask for more information. If the claimant can't provide it, and there's no extenuating circumstances, then the claim will probably be denied.
I see. Thank you.
Sure. All right. Any other questions?
Yes, do you actually have a number of property damages? In other words, X number of homes?
There's
20,000 claims, but
yeah, there's 24,000 properties that were damaged.
Thank you.
I believe that is it, Chair. No emails, no. Let me check the chat.
All right. Going once?
Nope.
Going twice? All right, everybody. Well, thank you so much. Let's do this again next Thursday. And if anybody has questions, please let us know. Take care. Bye-bye.
Thank you.